Chapter 10. Establishment of Child Support and Medical Support Obligations. Introduction. The Child Support Program serves nearly 1 in 5 children in the United States, providing 41% of family income to poor families who receive support payments and lifting 1 million people out of poverty every year. With the time limits on temporary assistance for needy families' TANF benefits, this additional source of income is especially important. Increased income flowing to the family can enable families to achieve economic stability and allow the custodial parent to enter the workforce by covering child care costs and providing a source of health care coverage. Establishing parentage and a support obligation also can connect a parent to a child, and thereby begin or restore a relationship between the child and the non-custodial parent. This chapter discusses the steps involved in establishing a support obligation and issues arising under child support guidelines. The information may be especially useful to the attorney preparing intergovernmental cases. Because guidelines are state-specific, the chapter contains information about how guidelines differ regarding the determination of income, factors to be included in calculations, and bases for deviation. The section on medical support focuses on the mandates for obtaining orders for health care coverage, the National Medical Support Notice (NMSN), and the Employee Retirement Income Security Act of 1974 (ERISA). Definition of child support. Traditionally, child support has been defined as cash contributions made on behalf of a minor child pursuant to an order or an agreement between the parents. This definition has evolved and broadened, however, and may include medical support, child care, and education expenses. Overview of the establishment process. Establishment of a child support order is vital to ensuring support for a child. Although a legal obligation to support a child may exist, it is not enforceable without a court order or an administrative order. Context. Before a tribunal can establish a child support order, it must first find that the person has a legal obligation to provide support to the child. This legal obligation may arise in several different contexts. Married parents. When parents are married, the child is presumed to be a child of the marriage, and establishment of a child support order most often occurs during separation or divorce proceedings. If a divorce order is silent on the issue of support, the custodial parent can later seek establishment of a support order. Unmarried parents. When parents are unmarried, there are a number of ways to legally establish parentage. For example, state or tribal law may create a legal presumption of paternity. Federal law requires states to have laws creating a legal presumption of paternity when genetic testing results indicate a probability of paternity above a certain threshold. Most states also have laws creating presumptions of paternity in cases where the child was born within a certain time after the marriage ended. Under the Uniform Parentage Act 2017, an individual is also a presumed parent if the individual resided in the same household as the child for the first 2 years of the child's life and openly held out the child as his own. When an unrebutted presumption or parentage exists, a tribunal has the legal authority to establish parentage and a support order. In cases where more than one presumption exists for the same person, the tribunal must determine which presumption controls. Additionally, federal law requires states to provide that a signed paternity acknowledgement constitutes a legal finding of paternity, subject to a 60-day rescission period. Federal requirements. Federal regulations require that within 90 calendar days of locating an alleged father or non-custodial parent, regardless of whether paternity has been established, an agency must either establish a support order or complete the service of process necessary to establish a support order and, if necessary, paternity or document unsuccessful attempts to serve process. A support order may also be entered on behalf of a caretaker or foster care agency when a tribunal has placed a child in the custody of a caretaker, relative, or agency. Standing. The custodial relative or caretaker for the child has standing to bring an action for support. In addition, the child can file by next friend a person appearing in or appointed by a court to act on behalf of a child lacking legal capacity where circumstances so merit. The next friend can be a guardian ad litem, appointed by a court to represent the minor child in a particular lawsuit, or it can be a relative or family friend of competent age, acting on behalf of the child without court intervention. The child support agency can also bring an establishment action, either because of an assignment of support rights in public assistance cases or because of a state statute giving the child support agency standing in Roman 4d cases. Jurisdiction. For a tribunal to enter a valid order for child support, there must be jurisdiction over the parties and the subject matter. Subject matter jurisdiction. Ordinarily, subject matter jurisdiction should not be a problem in child support cases. In judicial proceedings, it is a matter of filing the petition in the proper tribunal. In an administrative case, it means acting within the authority of the administrative agency. When a challenge to subject matter jurisdiction arises in a child support case, it is usually in the context of modification under the Uniform Interstate Family Support Act (UFSA). Personal jurisdiction. A tribunal must have personal jurisdiction in order to establish a support order. Where the non-custodial parent is physically present in the forum state, personal jurisdiction is usually not an issue. Gaining personal jurisdiction over a non-resident non-custodial parent, however, can present challenges. The attorney should review the facts of the case to determine if there is a basis for asserting long-arm jurisdiction. Every state has enacted UFSA 2008, which includes expansive long-arm provisions. Federal regulations require initiating child support agencies to determine whether it is appropriate to use long-arm jurisdiction as part of the initial investigation into an intergovernmental case. Although child support agencies rely on caseworkers to do the majority of case preparation, most agencies require review by an attorney before filing a pleading seeking establishment based on long-arm jurisdiction. The attorney must ensure that the facts satisfy the long-arm statutory provisions as well as due process requirements. Service of process. Whether the establishment action is filed within the state or forwarded to another state, tribe, or country for filing under that jurisdiction's law, the law of the forum jurisdiction governs service of process on the non-custodial parent. States promulgate rules for service of process that are, for the most part, based upon the federal rules of civil procedure. Many jurisdictions allow service of establishment pleadings by certified or registered mail, return receipt requested. Others require personal service. Some states have electronic filing systems for service of process and documents, and some state and federal cases have addressed service of process by email and Facebook. In an administrative system, the agency may mail the non-custodial parent a notice of support debt. Child support attorneys should review their jurisdiction's service of process requirements to determine what type of service is allowed. Elements of proof. Before a tribunal will issue a support order, it requires that the attorney prove the following for purposes of applying the support guidelines: the existence of a legal obligation to pay support by the alleged non-custodial parent, either by proving that the alleged non-custodial parent is the parent of the child in question, or the alleged non-custodial parent has a parental relationship with a child. Justifying establishment of a support duty, and the non-custodial parent's income and the custodial parent's income in many states. There are many electronic sources of income information that a Roman 4d attorney can review, including quarterly wage data from the Federal Parent Locator Service (FPLS), data from the National Directory of New Hires (NDNH), and financial institution records from the Multi-State or Single-State Financial Institution Data Match (FIDM), in addition to any state-specific databases that may be available. Many guidelines expressly require the parties to document their income through income tax returns and pay stubs. In examining pay records, the attorney should seek at least 1 year's worth of pay stubs, as income can fluctuate monthly in many jobs. Pay stubs from the end of the year are particularly significant, as they reveal the actual taxes paid over the course of the year and the total of all paycheck deductions. Most states also require parties to complete a standardized financial affidavit. There are certain circumstances in which the child support attorney might want to conduct additional discovery. Where a person owns a Subchapter S corporation or operates a cash-based business, the attorney should carefully scrutinize the person's income and expenses. Another situation is when a person's lifestyle seems to far exceed the income the person is claiming. There could be hidden income that the attorney can discover, or it might be appropriate to advocate for imputing income. Keep in mind that federal regulations address imputation of income by requiring a specific analysis of each individual non-custodial parent's situation. As discussed in more detail later in this chapter, if the child support attorney has a case where information about the non-custodial parent's earnings and income is unavailable or insufficient, the child support agency and attorney must search such factors as the non-custodial parent's assets, residence, employment and earnings history, job skills, educational attainment, literacy, age, health, criminal record and other employment barriers, and record of seeking work, as well as the local job market, the availability of employers willing to hire the non-custodial parent, prevailing earnings level in the local community, and other relevant background factors in the case. The State Employment Commission is a helpful resource. Once there has been a thorough search of these factors, using the discovery methods at the attorney's disposal, the attorney will be in a much better position to present evidence in support of a recommended income level for the tribunal to use in applying the child support guidelines. Defenses. In an establishment case, when parentage has not been determined by law, the alleged non-custodial parent can raise a non-parentage claim. In cases where the alleged non-custodial parent is alleged to be the biological parent, genetic testing usually resolves such a claim. When the legal relationship between the child and parent has already been established, there are a limited number of challenges to a petition to establish support. The fact that support is already being provided does not preclude a civil action to obtain an order for support. A decision-maker may entertain defenses such as the following. The petitioner has served the wrong person. The tribunal lacks personal jurisdiction over the parties. The non-custodial parent is living with a minor child for whom support is sought as the primary caregiver in an intact two-parent household or is receiving TANF benefits. The child is emancipated or an order of support entitled to recognition is already in place. Both the Full Faith and Credit for Child Support Orders Act FFCCSOA and UFSA prohibit entry of a de novo order in such a circumstance. Child Support Guidelines. Federal requirements. In an attempt to increase the use of objective criteria in the establishment of child support orders, the Child Support Enforcement Amendments of 1984 required states, as a condition of receiving federal funds, to develop mathematical calculations to determine appropriate child supports awards. Initially advisory, the Family Support Act of 1988 required that the guideline calculation must create a rebuttable presumption that it is the appropriate amount of support. If the tribunal deviates from the guideline amount, it must make a written finding or specific finding on the record that the application of the guidelines would be unjust or inappropriate. Regulations governing child support guidelines are at 45 CFR 302.56. They were significantly amended in 2016 when the Federal Office of Child Support Enforcement (OCS) published the Flexibility, Efficiency, and Modernization in Child Support Enforcement Programs Final Rule. The final rule's goals included increasing regular, on-time payments to families and reducing the accumulation of unpaid child support arrears. It emphasized that the support obligation or recommended support obligation amount should be based on the actual earnings, income, and ability to pay of the non-custodial parent in the specific case. Federal regulations at 45 CFR 302.56c require that child support guidelines must, at a minimum, provide that the child support order is based on the non-custodial parent's earnings, income, and other evidence of ability to pay. In order to achieve that, the guideline must take into consideration all earnings and income of the non-custodial parent, and at the state's discretion, the custodial parent. Take into consideration the basic subsistence needs of the non-custodial parent, and at the state's discretion, the custodial parent and children who has a limited ability to pay by incorporating a low-income adjustment, such as a self-support reserve or some other method determined by the state, and if imputation of income is authorized, take into consideration the specific circumstances of the non-custodial parent, and at the state's discretion, the custodial parent to the extent known, including such factors as the non-custodial parent's assets, residence, employment and earnings history, job skills, educational attainment, literacy, age, health, criminal record and other employment barriers, and record of seeking work, as well as the local job market, the availability of employers willing to hire the non-custodial parent, prevailing earnings level in the local community, and other relevant background factors in the case. In addition, the guideline must address how the parents will provide for the child's health care needs through private or public health care coverage and/or through cash medical support. The guidelines must provide that incarceration may not be treated as voluntary unemployment in establishing or modifying support orders. Finally, the guidelines must be based on specific descriptive and numeric criteria and result in a computation of the child's support obligation. In order to ensure their application results in an appropriate child support amount, states must review their guidelines at least once every 4 years and revise them if appropriate. The final rule added requirements concerning the guideline review. As part of the review, a state must 1. Consider economic data on the cost of raising children, labor market data such as unemployment rates, employment rates, hours worked, and earnings by occupation and skill level for the state and local job markets, the impact of guidelines policies and amounts on custodial and non-custodial parents who have family incomes below 200% of the federal poverty level, and factors that influence employment rates among non-custodial parents and compliance with child support orders. 2. Analyze case data gathered through sampling or other methods on the application of and deviations from the child support guidelines, as well as the rates of default and imputed child support orders and orders determined using the low-income adjustment required under paragraph C1 Roman II of this section. The analysis must also include a comparison of payments on child support orders by case characteristics, including whether the order was entered by default, based on imputed income, or determined using the low-income adjustment required under paragraph C1 Roman II. The analysis of the data must be used in the state's review of the child support guidelines to ensure that deviations from the guidelines are limited and guideline amounts are appropriate based on criteria established by the state under paragraph G, and 3. Provide a meaningful opportunity for public input, including input from low-income custodial and non-custodial parents and their representatives. The state must also obtain the views and advice of the State Child Support Agency funded under Title Roman IV-D of the Act. The state must publish on the Internet and make accessible to the public all reports of the guidelines reviewing body, the membership of the reviewing body, the effective date of the guidelines, and the date of the next quadrennial review. Federal regulations governing tribal child support programs recognize tribal sovereignty and the importance of allowing tribes to administer their Roman IV-D child support programs in a way that best meets the needs of tribal children and their families, consistent with their values and cultures. The requirements governing child support guidelines are at 45 CFR 309-105. Tribes must establish one set of child support guidelines for setting and modifying support obligation amounts that result in a rebuttable presumption of the correct support amount. The guidelines must, at a minimum, take into account the needs of the child and the earnings and income of the non-custodial parent, and be based on specific descriptive and numeric criteria and result in a computation of the support obligation. Tribal guidelines may permit non-cash payments to satisfy support obligations. If they do, the guidelines must require tribal support orders allowing non-cash payments to also state the specific dollar amount of the support obligation. Describe the type S of non-cash support that will be permitted to satisfy the underlying specific dollar amount of the support order, and provide that non-cash payments will not be permitted to satisfy assigned support obligations. The tribunal must apply the guidelines unless there is a written finding or a specific finding on the record that the application of the guidelines would be unjust or inappropriate in a particular case in accordance with criteria established by the tribe or tribal organization. The guidelines must be reviewed and revised, if appropriate, at least once every 4 years. Overview of guideline models. Federal regulations provide that guidelines can be established by law or by judicial or administrative action. Each state develops its own guidelines, the use of which is binding on judges and other officials who set child support awards. All states use one of 3 guideline models: income shares, percentage of income, or the Melson formula. Income shares. The income shares model is the most common model in the states. It is based on the premise that both parents should share in the expenses of the family proportionate to their incomes, and that the child should continue to receive the same amount of support as the child would have received had the parents never separated or divorced. This same premise is applied to the children of unmarried parents. Under this model, the decision-maker first determines the income of each parent and consults a table to determine the basic child support obligation at that combined income level. The tables vary from state to state and are typically based on economic estimates of child-rearing expenditures minus average amounts for health insurance, child care, and extraordinary medical expenses for a child. The basic support amount also varies based on factors, such as the number of children. The presumed basic needs of the child are met by the figure from the table. Then expenses, such as work-related child care costs, health insurance premiums, and extraordinary medical expenses, are added as appropriate. The total is then prorated between the parents based on their proportionate shares of the total available income. This type of formula can be based on either gross or net parental income. The person with primary physical custody of the child is presumed to be contributing his or her proportionate share of the total support obligation directly to the child. The tribunal orders the non-custodial parent to pay his or her proportionate share of the support obligation as the child support award. Percentage of income. The percentage of income model bases the support amount on a percentage of the income of the non-custodial parent and the number of children to be supported. The basic percentages vary from state to state. Some states using the percentage of income model may consider other factors, such as the age of the children. There are two variations of the percentage of income method: flat percentage and varying percentage. Under a flat percentage formula, the portion of income devoted to child support does not vary regardless of the income of the non-custodial parent. A varying percentage formula provides for an increasing percentage of the non-custodial parent's net income at low income and mid-income levels, then caps it with a constant percentage after it reaches a certain level. Under the percentage of income model, the tribunal does not consider the income of the custodial parent. The tribunal calculates the support amount by first determining the non-custodial parent's income. It then determines the basic order by taking the appropriate percentage of that income based on the state's law. The tribunal may adjust the basic support amount for add-ons or deductions, which are discussed in detail later in this chapter. Melson formula. The Melson formula, a hybrid of the cost-sharing and income-sharing models, requires that each parent's basic needs be met before child support is set. It is premised on the allocation of a poverty-level amount to each parent before determining the child's needs. The three underlying principles of the Melson formula are that 1. Parents are entitled to keep sufficient income to meet their basic needs to encourage continued employment. 2. Until the basic needs of the child are met, parents should not be permitted to retain any more income than that required to provide the bare necessities for their own self-support. And 3. Where income is sufficient to cover the parent's basic needs and those of the dependent, the child is entitled to share in any additional income and benefit from the non-custodial parent's higher standard of living. The Melson formula considers the primary needs of the child, work-related child care expenses, extraordinary medical expenses, and any standard of living adjustment before allocating the child's total needs between the parents based on a percentage of income of each. Although the use of only 3 guideline models by states would suggest that child support orders established using a particular model would not vary much from state to state, there are, in fact, many differences among the states in the application of a model. These include differences in the definition of income, how and when to impute income, and whether gross or net income is used. Differences also exist in how the guidelines consider other factors. Choice of law. The governing child support guideline will be that of the foreign jurisdiction. For intergovernmental cases, that means it will usually be the law of the responding state. Application of child support guidelines. It is important that tribunals enter child support orders based on a non-custodial parent's realistic ability to pay. The child support attorney plays a vital role in the establishment of child support orders by documenting on a case-by-case basis all allowable sources of income for each party. following regulatory requirements concerning imputation of income when income information is unavailable or insufficient, presenting to the tribunal a proposed support amount using the applicable guideline, and proposing a deviation from the guideline amount when appropriate. In the final rule, OX expressed concern that some states had reduced their case investigation efforts about a non-custodial parent's present circumstances or sustained ability to pay support. The regulations require state Roman 4D agencies to use tools such as investigations, case conferencing, interviews with both parties, appear and disclose procedures, parent questionnaires, testimony, and electronic data sources to determine income of an obligor. Child support attorneys will likely be involved in the use of some of these tools. The final rule noted that orders issued in Roman 4D cases should not reflect a lower threshold of evidence than applied in private cases represented by legal counsel. Definition of income. Federal regulations require that guidelines must consider all earnings and income of the non-custodial parent. Some guideline models consider the incomes of both parents, including the earnings and income of the custodial parent in the calculation, while other models are based primarily on the income of the non-custodial parent. Regardless of the model used, the computation of income, based upon each state's definition for the purposes of calculating child support, is the critical first step in establishing a child support order. States use varying definitions of what constitutes income, and these definitions are often very broad. At least one state's definition of income ends with potential cash flow from any source. Salary and resources. All guidelines require the tribunal to consider earned income of one or both parties when determining a support order. Typically, this income is salary, but all states offer lists of resources that can be included in income. Often these include commissions, bonuses, tips and perquisites, rental income, estate or trust income, royalties, interest, dividends and annuities, self-employment earnings, alimony, in-kind and fringe benefits, and lottery winnings. North Dakota includes as in-kind income, income-producing activity of any valuable right or property interest, and the use of consumable property or services at no charge or less than the customary charge. New York allows consideration of non-income producing assets at the discretion of the court, and Wisconsin includes undistributed income of a corporation and contributions to an employee benefit plan. Some support guidelines expressly address military pay. The examples of income are listed in the guidelines themselves and are often expanded upon in case law. Under many support guidelines, income includes inheritance and one-time benefits, such as lottery winnings or personal injury awards. 61 Generally, most states also include interest and dividends in their definitions of income. There is case law suggesting that the tribunal may even include income from a one-time capital gain. Commissions. Most state guidelines consider commissions as income. The issue is how long a period to use in computing an average when commission payments are sporadic. Most state guidelines also include royalties and bonuses, even severance pay, in their definition of what constitutes gross income, even though they may not be recurring payments. Income from overtime, second job, and seasonal employment. State support guidelines vary in how they treat income from overtime, second jobs, or seasonal employment. Some states, such as Florida, Kansas, and Texas, expressly include overtime or periodically received income within their definition of gross income. Other state support guidelines expressly exclude overtime or seasonal income from the definition of gross income if, in the court's discretion, the inclusion would be inequitable to a party. Colorado includes overtime within the definition of gross income only if the overtime is required by the employer as a condition of employment. Other states, such as California, provide the tribunal discretion to consider such income. States also vary in their treatment of income from second jobs in excess of a 40-hour work week. Although federal policy prohibits the categorical exclusion of such income from consideration under child support guidelines, state guidelines may provide that application of the guidelines to such income may be rebutted as unjust or inappropriate on a case-by-case basis in accordance with state criteria. When overtime or second job income occurs regularly, the child support attorney can calculate the income the parent consistently receives from such employment and include it within the parent's gross income, if permitted, in the guideline calculation. When it is not a regular occurrence, the child support attorney can calculate income based on the average of overtime over a period of time. Other benefits. Most states include Social Security retirement benefits, other pension or retirement benefits, disability insurance benefits, workers' compensation benefits, and educational grants or subsidies as income. However, benefits intended to assist needy families, including TANF and Supplemental Security Income (SSI), are excluded from income for the purpose of calculating child support. Self-employment income. If the parent is a business owner or other self-employed individual, the child support attorney needs to conduct detailed research in order to determine the parent's correct income. Income from self-employment often fluctuates by definition and is not always readily apparent from a review of the individual's tax returns and other business records. The attorney should also carefully scrutinize the reasonableness and appropriateness of business decisions that lessen the amount of income available for child support. A self-employed parent's business deductions should be reviewed in order to ensure the parent has not sheltered income at the expense of lessening income available for child support. A relatively new but quickly growing type of self-employment is known as the gig or freelance economy. The gig economy is a labor market characterized by the prevalence of short-term contracts or freelance work gigs as opposed to permanent jobs. Usually, online platforms connect workers and customers, and payment is intermediated by the platforms. Non-custodial parents who work in the gig economy may work at a variety of one-time or different types of jobs. They work whenever they want and are paid a rate for a specific task. Gig workers are not considered employees under most states' income withholding laws, so employers are not required to report them to new hire directories. Also, parents' incomes in the gig economy often vary greatly from month to month. If the non-custodial parent is working in the gig economy, it may be necessary to subpoena the parent's bank and other financial records, such as income tax returns, in order to determine the parent's income. The attorney can subpoena company records to determine whether a particular non-custodial parent works there or has worked there in the past. And the attorney can send subpoenas to the registered agent of a company that is headquartered in another state. In the case of taxi or other gig driving and delivery services, the attorneys can subpoena trip sheets. Certified public accountants or forensic accountants may be helpful in locating gig income. Because there may be a significant cost involved when engaging accountants for this type of investigation, attorneys should secure agency approval for the expense. In-depth interviews with custodial parents and exploration of social media sites may also be useful in identifying income sources. Most state guidelines contain a separate definition of gross income for self-employed individuals. These definitions usually include a comprehensive list of income sources such as self-employment, proprietorship of a business, partnership, and closely held or subchapter S corporations. Nebraska's definition is even more expansive, including income that could be acquired by the parties through reasonable efforts, and provides an example of retained earnings from closely held corporations. Most guidelines also require the subtraction from gross income of ordinary and necessary business expenses required to produce income. States define ordinary and necessary business expenses in several ways, including 1/2 of the self-employment tax actually paid, a reasonable yearly deduction for necessary capital expenditures, and straight-line depreciation for the life of the asset, and 1/2 of the self-employment Social Security tax paid on the trade or business income. In the case of a self-employed individual, the child support attorney needs to know which income sources and IRS forms to research. However, the attorney needs to keep in mind that information on tax returns may be misleading and often does not accurately reflect a self-employed individual's actual spendable income. Child support guidelines should be calculated on actual cash flow and not on the income reported on a tax return. Therefore, child support attorneys need to begin by reviewing the information contained in tax returns, but also must understand the difference between income reported on a business tax return and actual cash flow to the self-employed individual. This will provide the attorney with a complete picture of the self-employed individual's ability to pay support. Self-employment income is reported in many different ways to the IRS, depending on the type of business or corporation involved. For example, a sole proprietorship that is unincorporated and owned by a single individual is required to report income from the business on that individual's personal income tax Schedule C. A standard or C corporation, on the other hand, reports corporate income on IRS Form 1E-120. Corporations are taxed on their income separately from any dividend or other income that may be paid to shareholders. A closely held C corporation may pay out all of its income to shareholders. In that case, each shareholder receives a W-2 form for that income. In the case of a Subchapter S corporation, all of the income is passed through to individual shareholders. This income is reported by the corporation on Schedule K, 1 IRS Form 1E-120, and to the shareholder on a W-2. In this case, it is important to understand that sometimes earnings appearing on the K-1 form do not actually represent income to the individual, but instead earnings retained by the corporation. If an individual is a partner in a business, partnership income is reported on IRS Form 1065. To determine the actual spendable income of the individual, other financial documents, such as balance sheets, statements of cash flow, and records of depreciation expenses should be carefully reviewed and compared to information from relevant IRS forms. For example, a business return might show no taxable income after depreciation of equipment, allowances for losses and inventory and business expenses, while the statements of cash flow may actually show income that could be available for calculating child support. In other cases, the self-employed individual may frequently receive in-kind payments from an employer, such as meals, lodging, tickets for sporting events, frequent flyer miles, and company-owned vehicles. Payments of this nature reduce personal expenditures and therefore free income for other purposes. In the case of a partnership, the partnership agreement will often contain information about the ownership interest the individual has in the partnership and information about the individual partner's allocation of income or loss. Statements of cash flow outline the net cash used during a particular period, and a balance sheet is a financial statement showing assets and liabilities of a business. In the case of depreciation expense records, a business may show an item as expensed all in 1 year or depreciated according to an accelerated schedule. Both of these methods artificially reduce the amount of income the business will report for the year in question. For this reason, state guidelines often require depreciation to be calculated differently than the business record shows. Kentucky provides that income used for the calculation will differ from a determination of business income for tax purposes and mandates that only straight-line depreciation be used, while Tennessee does not allow any kind of depreciation as a reasonable business expense. Some states, such as Indiana, say that self-employed income and expenses should be carefully reviewed to restrict the deductions to reasonable out-of-pocket expenditures necessary to produce income. Dealing with self-employed parents can become very complicated. In some cases, a child support attorney may benefit from the services of an accountant to assist in reviewing business records and determining the appropriate amount of income to use in calculating a child support guideline order. Gross income v. net income. There is no requirement in federal law or regulations about whether states should base the support guidelines on the gross or net incomes of the parties. About half of the states use gross, or a form of adjusted gross income. Most gross income-based guideline schedules adjust for federal and state income taxes and FICA. Other adjustments vary. Many states include an adjustment for child or spousal support payments actually paid. Massachusetts allows adjustments for reasonable child care, health care coverage, and dental vision insurance. Ohio and Oregon allow an adjustment for mandatory union or labor organization contributions, and Rhode Island allows pension payments, life insurance premiums, and payments for marital debts to be deducted in the discretion of the court. The remaining states base their support guidelines on the net income of the parties, which is not necessarily net income for purposes of income taxes. Many definitions of net income are very similar to adjusted gross income. For example, net income is typically defined as gross income minus deductions for federal, state, and local taxes, and includes other deductions, such as mandatory contributions to retirement plans, mandatory union dues, or mandatory job-related expenses. Some states, such as Connecticut, allow for deductions of other support orders and health insurance premiums. Using net income allows the tribunal to consider the actual income available to pay support and captures differences in the tax implications of the dependency deduction for the custodial parent. However, it is also subject to manipulation by the parties. For example, an attorney should be aware that a party might be able to manipulate the amount of net income by changing the number of exemptions claimed for federal tax purposes. Also, some view net income as inequitable. Because it usually only recognizes mandatory deductions, it allows the working parent a deduction for retirement contributions, but does not allow a parent a deduction for a voluntary pension contribution. It may be appropriate for an attorney to request a deviation from the guideline amount in order to allow a non-working parent a deduction for such voluntary contributions. Imputation of income. Attribution of income based on a person's earning capacity is called imputation of income. Every state child support guideline allows consideration of a person's earning capacity when the person is voluntarily unemployed or underemployed in order to calculate an appropriate amount of child support. Usually, tribunals look at the reason for the reduced income. If there is evidence that the parent has voluntarily reduced his or her income in order to avoid paying child support, the tribunal will usually impute income to the parent. On the other hand, if the parent has gone back to school or taken a different, lower-paying job because of the potential for future growth and earnings, the tribunal may find that there is a valid reason for the reduced income. Other courts, while appreciating the rights of the individual for personal growth, have found that a parent cannot act in a way that will have a detrimental effect on the child's well-being. A parent is generally not required to relocate or switch careers to maximize income, and where relocation has resulted in reduced income due to the job market in the new location, courts often do not impute higher income if the purpose of the relocation is to foster the parent-child relationship. Courts have also considered whether to impute income to a custodial parent who chooses not to work. Most states prohibit the imputation of income to a custodial parent of a child of tender years. The other circumstance in which a tribunal may impute income is when a non-custodial parent fails to appear at the hearing after proper service. Ox was particularly concerned about imputation in this circumstance when it promulgated the final rule. In the response to comments, Ox expressed concern that some states had reduced their case investigation efforts and routinely set orders based on imputed income that bore no relation to the non-custodial parent's present circumstances or sustained ability to pay support. Some state guidelines imputed income at a minimum wage when specific facts about a non-custodial parent's income were not readily apparent. Other states imputed income to incarcerated non-custodial parents on the premise that they were voluntarily or willfully unemployed. Ox noted, overuse of imputed income frequently results in Roman 4D orders that are not based on a realistic or fair determination of ability to pay, leading to unpaid support, uncollectible debt, reduced work effort, and underground employment. Because such orders are not based on the non-custodial parent's ability to pay, as required by federal guidelines law, they typically do not yield consistent payments to children. The final rule requires a child support agency to gather information regarding the earnings and income of the non-custodial parent. If earning and income information is unavailable or insufficient in a case, and the support guidelines authorize imputation of income, such imputation must take into consideration, to the extent known, such factors as the non-custodial parent's assets, residence, employment and earnings history, job skills, educational attainment, literacy, age, health, criminal record and other employment barriers, and record of seeking work, as well as the local job market, the availability of employers willing to hire the non-custodial parent, prevailing earnings level in the local community, and other relevant background factors in the case. The factual basis for the support obligation must be documented in the case record. In addition, the regulation prohibits the guideline from treating incarceration as voluntary unemployment in establishing support orders. That means state guidelines which authorize imputation of income must provide for consideration of the actual circumstances of the non-custodial parent. Some states impute income by considering assets owned by the parent. This is particularly true for the self-employed who have low retained earnings and return significant income to the company. If the party has invested in assets that could be income-producing, the child support attorney could advocate for an addition of reasonable interest and dividends to the income figure. Some states give the tribunal discretion to consider assets that do not produce income. Wisconsin, for example, includes a separate definition of income imputed from assets, which includes the amount of income ascribed to assets that are unproductive and to which income has been diverted to avoid paying child support, or from which income is necessary to maintain the child or children at the standard of living they would have if they were living with both parents, and that exceeds the actual income from the assets. Ohio allows imputed income from any non-income producing assets of the parent as determined from the local passbook savings rate or other appropriate rate. Many states also include in-kind income in their definition. North Dakota, for example, includes in-kind income and amounts received in lieu of actual earnings. Establishment of realistic orders in low-income cases. Minimum support amount. Historically, state guidelines have followed various approaches in setting support awards for low-income parents. One approach used by most support guidelines is to establish a minimum support amount that is a rebuttable presumption of the appropriate amount of support. 109. The guidelines often provide examples of facts a court may use to set a discretionary support order lower than the minimum amount. Such factors may include resources and living expenses of the parties, number of children, and the physical or mental disability of the non-custodial parent. When finalizing amendments to child support regulations in 2016, OX voiced concern about minimum support orders that were not based on the circumstances of a particular obligor. Over time, we have observed a trend among some states to reduce their case investigation efforts and to impose high standard minimum orders without developing any evidence or factual basis for the child support ordered amount. Our rule is designed to address the concern that in some jurisdictions, orders for the lowest income, non-custodial parents are not set based upon a factual inquiry into the non-custodial parent's income and ability to pay, but instead are routinely set based upon a standardized amount well above the means of those parents to pay it. The final rule requires child support agencies to take reasonable steps to develop a sufficient factual basis for the support obligation. This must include gathering information on a case-by-case basis regarding the earnings and income of the non-custodial parent, as well as detailed information about the specific circumstances of the non-custodial parent. OX noted that high minimum orders that are issued across the board without regard to the non-custodial parent's ability to pay the amount do not comply with these regulations. Consideration of basic subsistence needs. The final rule also requires child support guidelines to take into consideration the basic subsistence needs of the non-custodial parent, and at the state's discretion, the custodial parent and children who has a limited ability to pay by incorporating a low-income adjustment, such as a self-support reserve or some other method determined by the state that is intended to ensure that a low-income parent can meet his or her own basic needs as well as permit continued employment. Our goal is to establish and enforce orders that actually produce payments for children. Both parents are expected to put their children first and to take the necessary steps to support them. However, if the non-custodial parent cannot support his or her own basic subsistence needs, it is highly unlikely that an order that ignores the need for basic self-support will actually result in sustainable payments. One of the unintended, but pernicious consequences of orders that are not based on ability to pay is that some non-custodial parents will exit low-wage employment and either avoid the system entirely or turn to the drug trade or other illegal activities to pay support obligations and contempt purge payments. It is not in children's best interests and counterproductive to have their parents engage in a cycle of non-payment, illegal income generation, and incarceration. As part of its quadrennial review of child support guidelines, each state must consider a wide variety of data, including Labor market data such as unemployment rates, employment rates, hours worked, and earnings by occupation and skill level for the state and local job markets. The impact of guideline policies and amounts on custodial and non-custodial parents who have family incomes below 200% of the federal poverty level, and factors that influence employment rates among non-custodial parents and compliance with child support orders. Each review must also include an analysis of case data on the application of deviations from the guidelines, as well as the rates of default based on imputed income or through use of any low-income adjustment. At the time of the final rule, almost all state support guidelines already included some type of self-support reserve or low-income adjustment. States using a self-support reserve usually base it on the U.S. Poverty Guideline for one person. The federal poverty guidelines are issued each year in the Federal Register by the Department of Health and Human Services and are used to determine eligibility for certain federal programs. Most states using the federal poverty guidelines identify the amount of the current federal poverty guideline for one person in their guideline and do not update the self-support reserve until the next quadrennial guideline review. A few states index their self-support reserve to the annual updating of the poverty income guidelines as reported by the Federal Department of Health and Human Services, which results in the self-support reserve also being updated annually. Many income share states incorporate a self-support reserve or low-income adjustment into their guideline schedule. Note, however, that if the guidelines explanation does not explicitly note that the schedule incorporates a self-support reserve or low-income adjustment, attorneys and parents may be unaware of the protection. Florida is an example of a state that provides a low-income adjustment as a separate calculation rather than as a component of the guideline schedule. Other state guidelines without a self-support reserve or low-income adjustment require the tribunal to carefully consider all the facts in order to determine a support amount that can be reasonably ordered without denying the obligor the means for self-support at a subsistence level. After a thorough investigation of all income sources for the non-custodial parent, the child support attorney should determine whether any low-income adjustment or self-support reserve within the state child support guideline is applicable. This calculation may not be needed in those states where the self-support reserve is built into the guidelines table itself. However, in states where a low-income adjustment must be applied as a separate step from the actual guidelines calculation, or the adjustment may be used in conjunction with a minimum support order, it may be appropriate for the attorney to propose an adjustment to the tribunal in recognition of the subsistence needs of the non-custodial parent and custodial parent under some state support guidelines. Establishment of orders in high-income cases. Treatment of high-income cases varies from state to state and even from tribunal to tribunal. There are three main approaches. First, some support guidelines include a numerical formula expressly for high-income cases. For example, Virginia, which uses an income shares model, has a special formula that a tribunal must use when gross income exceeds $10,000 per month, and Florida guidelines provide that the obligation is the minimum amount of support provided on the schedule, plus a percentage multiplied by the amount of income that exceeds a certain amount per month. A second approach is to presume that the highest amount provided for in the guideline is the correct amount, and allow a tribunal to deviate above that amount based on certain statutory factors. For example, the Arizona guidelines provide that a party seeking a sum greater than the presumptive amount bears the burden of proving that the higher amount is in the best interest of the children, taking into account such factors as the standard of living the children would have enjoyed if the parents and children were living together, the needs of the children in excess of the presumptive amount, consideration of any significant disparity in the respective percentages of gross income for each party, and any other factors which, on a case-by-case basis, demonstrate that the increased amount is appropriate. Connecticut's guideline provides that when the parents' combined net weekly income exceeds $4, seasoned child support awards shall be determined on a case-by-case basis, consistent with statutory criteria. However, the guideline also establishes a minimum presumptive amount and a maximum presumptive amount for high-income cases. Finally, in some states using the income shares model, the guideline schedule addresses combined incomes to a certain level, and allows the tribunal expansive discretion in determining a support amount where the combined income exceeds the highest level specified in the schedule. For example, the guidelines in Alabama and Maryland simply provide that if the combined adjusted actual income exceeds the highest level specified in the schedule, the court may use its discretion in setting the amount of child support. Georgia's guidelines permit the court or the jury to consider an upward deviation to attain an appropriate award of child support for high-income parents, which is consistent with the best interest of the child. Mississippi, which uses a percentage of income model, also allows the court-wide latitude. Its guidelines provide that in cases where the adjusted gross income of the non-custodial parent is more than $100,000, the court must make a written finding in the record as to whether the application of the guidelines is reasonable. Some appellate courts have held it is appropriate for the trial court, in exercising its discretion in high-income cases, to award support at a level that allows the child to share in the standard of living of the high-income parent. Other appellate courts have ruled that the trial court may consider the reasonable needs of the child. A Georgia court struck down an upward deviation from the guidelines amount that equaled 18% of the non-custodial parent's gross monthly income, finding it punitive and premised in part on an attempt to compensate the child for the relatively low child support payments made in the past despite the parent's expenditures of enormous sums on gambling. To avoid windfalls to the custodial parent, courts or administrative agencies can require funds in excess of the child's actual needs to be placed in a trust for the future. Effects of custody and shared parenting time. Where parents are separated or divorced, there may be a number of different parenting time arrangements. Sole custody of children to one parent, with the other parent having the opportunity to spend time with the children. Split custody, where one or more children are awarded to one parent, while other children are awarded to the other parent. Joint legal custody, where both parents share legal custody of the child or children, with living arrangements and visitation time specified. Or shared parenting, where the children's time is shared between the parents. These arrangements are usually pursuant to a voluntary parenting agreement or a court order. Recognizing this, most states now have some type of shared parenting time formula built into their guidelines that is implemented either as a formula within the guidelines or as a deviation from the standard guideline formula. Sole custody. All guidelines use a basic formula or percentage of income for cases where one parent has sole custody. Many then implement a parenting time adjustment after the basic support amount is calculated. Most of the guidelines with parenting time adjustments make no adjustment unless the child is with the non-custodial parent more than 25 to 35% of overnights per year. Shared or joint custody. Most state guidelines address shared or joint custody situations in which the child spends extensive time with the non-custodial parent. The most common approach is to establish a threshold amount of parenting time in excess of the ordinary 25 to 35% of overnights, at which level support is adjusted on a sliding scale. To compute the adjustment, usually the basic child support guideline obligation is multiplied by some specified amount to account for the parents duplicating certain types of expenses for the child. The threshold at which there is a support adjustment varies among states that use one. In Maryland, the formula for shared custody is used when the threshold of 35% of overnights is met. After the threshold is met, the court requires evidence that both parents contribute to the expenses of the children in addition to the payment of child support. Contrast that with South Dakota, where the court may, if deemed appropriate, abate support if the child resides with the obligor 10 or more nights in a month pursuant to a custody order. The statute establishes the minimum and maximum amount of abatement and instructs the court to consider whether the abatement would have a substantial negative effect on the child's standard of living in making its decision. Usually adjustments for shared physical custody and parenting time are considered in the guideline worksheet. Finally, several states treat shared physical custody as a deviation factor. Instead of a particular formulaic method of calculating a child support amount under circumstances of shared or joint custody, these states allow the decision-maker to adjust the calculated support amount to reflect to current custody arrangements. Orders are less likely to be consistent under similar circumstances using this method. Split custody. In split custody cases, each parent is awarded custody of at least one child. The most common approach involves an offset. The tribunal calculates the support that each parent would owe to the other for the support of the child in his or her custody. The tribunal then offsets the two amounts against each other. The parent who owes the greater amount pays the difference to the other parent. The second approach is used by just a few states. In those states, split custody is considered a deviation factor, with the amount of the support award at the discretion of the decision maker. Add-ons to basic support amount. Although the goal of guidelines is to standardize child support awards as much as possible, there are some aspects of support that are so variable that they require separate consideration. While basic needs, such as food, shelter, and clothing, remain consistent, other expenses attributable to children do not. These include child care and medical expenses. Child care. For many parents with young children, child care is essential for the parents to work or attend school or training to increase their employability. The care may be in a family daycare setting, center-based care, after-school care, or through an individual child care provider. Because child care expenses vary so greatly depending on family circumstances, child support guidelines do not include them within the basic support schedule. The most common approach, regardless of the guidelines model used, is to add the child care costs to the basic support amount and then allocate the cost between the parents. If both parents share significant parenting time with the children, many income shares guidelines provide that child care expenses for both parents may be considered. Usually states address actual child care cost incurred. A few states limit the amount of child care expenses that the tribunal can consider. For example, Oregon provides for an adjustment in the support amount for child care costs that are reasonable and do not exceed applicable tables. Table 1 establishes maximum allowable child care costs by provider location, and other employment-related day care allowance tables establish maximum amounts allowed by the Department of Human Services. Because adding an allocation of child care expenses to the support schedule amount can result in a large support award, a few states set an overall cap on the total support award or permit a deviation if the total order amount exceeds a certain threshold. Guidelines may also subtract the value of the federal income tax credit for child care from the actual costs to arrive at a figure of net child care expenses. Washington's guideline is unique in requiring the custodial parent to repay the obligor if the child care expenses are not incurred. Medical expenses. Federal law requires that all child support orders enforced by the Title IV-D program must include a provision for medical support for the child to be provided by either or both parents. Implementing federal regulations require the state IV-D agency to petition the tribunal to include health care coverage that is accessible to the children, as defined by the state, is available to the parent responsible for providing medical support, and can be obtained for the child at reasonable cost. The agency must also petition the tribunal to allocate the cost of coverage between the parents. If health care coverage is not available at the time the order is entered, the agency must petition the tribunal to include cash medical support until such time as health care coverage that is accessible and reasonable in cost becomes available. There are three categories of medical expenses that support guidelines typically address: health insurance, ordinary medical expenses, and extraordinary medical expenses. All three are within the regulatory definition of cash medical support. Federal regulation defines cash medical support to include both amounts ordered to be paid toward the cost of health insurance provided by a public entity or by another parent through employment or otherwise, and amounts for other medical costs not covered by insurance. These costs encompass a range of items that include co-payments, medicine costs, uncovered procedures and conditions, as well as cash payments in lieu of health insurance. Since the regulation does not provide specific guidance on how support guidelines should address these expenses, states have developed a variety of mechanisms for addressing them within child support orders. There is additional discussion on the establishment of a medical support order later in the chapter. Health insurance. The Patient Protection and Affordable Care Act (AK), passed in 2010, defines health care coverage, known as minimum essential coverage in the Act, to include government-sponsored programs such as Medicare, Medicaid, Children's Health Insurance Program CHIP, or TRICARE, employer-sponsored coverage, coverage purchased under the individual market, grandfathered health plans, or other coverage. In response, OX amended 45 CFR 300-331 to define health care coverage in the child support context as a fee-for-service, health maintenance organization, preferred provider organization, and other types of private health insurance and public health care coverage under which medical services could be provided to the dependent child (REN). Some states define health insurance to include additional providers. For example, Oklahoma includes coverage from the Indian Health Service and the Defense Eligibility Enrollment Reporting System (DEERS). In the final rule, OX also amended the definition of reasonable costs for health care coverage in the context of establishing a medical support obligation. Cash medical support or the cost of health insurance is considered reasonable in cost if the cost to the parent responsible for providing medical support does not exceed 5% of his or her gross income or, at state option, a reasonable alternative income-based numeric standard defined in state law, regulations, or court rule having the force of law or state child support guidelines. As states proceed with quadrennial child support guideline reviews, they have updated their guidelines to reflect current federal requirements governing health care coverage. For example, Michigan now defines reasonable cost of coverage as that which does not exceed 6% of the providing parent's gross income. The Michigan guideline also provides that a parent's cost of providing health care coverage is unreasonable if the total obligation for support, child care expenses, ordinary health care expenses, plus the parent's net share of health care insurance is greater than 50% of the parent's regular, aggregate disposable earnings. Ohio support guidelines provide that the total actual out-of-pocket cost of a health insurance premium paid or expected to be paid cannot exceed 5% of the annual income of the paying parent. Because the cost of insurance varies so greatly, states do not include it within the basic guideline amount. Instead, most guidelines add the actual cost of the child's health insurance to the basic support amount and then prorate the cost between the parents based on their proportion of income. Usually, guidelines determine the cost of the child's health insurance premium by looking at the difference between single and family coverage or the cost of adding a dependent child. Some state guidelines allocate insurance costs between the parents, and some order one parent to pay for health insurance and then deduct that cost from the paying parent's income. This latter approach is the one that Nebraska follows. The Nebraska guidelines provide that the increased cost to the parent for the child's health insurance must be allowed as a deduction from gross income. The parent requesting an adjustment for health insurance premiums must submit proof of the cost of the premium. Ordinary medical expenses. Definition. Some states provide a definition of medical expenses. For example, some list reasonable costs for medical, dental, orthodontia, optometric, counseling, mental health treatment, substance abuse treatment, treatment for chronic conditions and asthma, and/or physical therapy as medical expenses. Michigan guidelines define medical expenses as treatments, services, equipment, medicines, preventative care, similar goods and services associated with oral, visual, psychological, medical, and other related care, provided or prescribed by health care professionals for the children. Ordinary medical expenses also include the support recipient's co-payments and deductibles, and uninsured medical-related costs for all children in the case. Other states simply refer, for example, to ongoing medical costs. Guideline treatment of ordinary medical expenses. Support guidelines that expressly address medical expenses vary in how they distinguish ordinary medical expenses from extraordinary medical expenses. Some states expressly provide that the basic support amount assumes a certain amount of unreimbursed medical costs. For example, the Alabama Schedule of Basic Child Support Obligations assumes unreimbursed medical costs of $200 per family of 4 per year. These assumed costs include medical expenses not covered or reimbursed by health insurance, Medicaid, or Medicare. Many states set a threshold amount for what constitutes an add-on medical expense. By implication, medical expenses that do not meet that threshold are subsumed within the basic support amount. For example, in New Jersey, unreimbursed health care expenditures of medical and dental, up to and including $250 per child per year, are included in the schedules. Such expenses are considered ordinary and may include items such as non-prescription drugs, co-payments or health care services, equipment, or products. The fact that a family does not incur that amount of health care expense is not a basis for deviating from the guidelines. Predictable and recurring unreimbursed health care expenses in excess of $250 per child per year are added to the basic support amount. In Connecticut, unreimbursed medical expenses are apportioned between the parties. In Indiana, uninsured expenses in excess of 6% of the basic support obligation are considered extraordinary medical expenses, resulting in an add-on to the basic amount. Expenses less than 6% of the basic child support obligation are considered ordinary expenses that are paid by the parent required to pay support, as part of the basic support amount. Other states take the approach that the basic support amount can be adjusted by adding the cost of any non-covered medical, dental, and prescriptive medical expense. Extraordinary medical expenses. Extraordinary medical expenses are those expenses that extend beyond the ordinary expectation of medical need in a family, as contemplated by most state guidelines. Definition. About 1/3 of the states and the District of Columbia define extraordinary medical expenses. There are several approaches to this definition. The most common approach is to define extraordinary medical expenses as unreimbursed medical expenses that exceed a certain amount per child per calendar year. Other approaches define extraordinary medical expenses as uninsured expenses in excess of a certain total amount per year, expenses for a single illness or condition, or those uninsured expenses that exceed a certain percentage of the basic obligation. Other states do not use the phrase extraordinary medical expenses or do not define it by a particular amount. They do, however, recognize an adjustment for certain unreimbursed medical expenses. Alabama, for example, allows the court to make an additional order for extraordinary medical, dental, and educational expenses if there is a written agreement between the parties to pay those expenses or if the order would be in the best interest of the child. Connecticut's guidelines split all uninsured medical costs proportionally between the parents based on their net disposable incomes. To calculate net disposable income for this purpose, the receiving it and subtract the same 80% from the income of the parent paying the alimony before calculating each parent's share of the uninsured medical costs. The guidelines also add any Social Security dependency benefit amounts for the children that are based on the earnings record of the non-custodial parent to the net disposable income of the custodial parent before calculating the parent's share of these costs. Some states simply allocate uninsured medical expenses over a certain amount or on a case-by-case basis. In some states, extraordinary expenses, including uninsured medical expenses, are listed among deviation factors for a tribunal to consider. Guideline treatment of extraordinary medical expenses. No state support guideline includes extraordinary medical expenses within the basic support amount. Such expenses are usually the basis for a deviation from the basic support amount or an add-on to the guideline amount. Deviations from support guidelines. Although tribunals must treat support guidelines as rebuttable presumptions of the appropriate amount of support, they may deviate from the guideline amount in certain circumstances. In order to do so, they must make a written or specific finding on the record of a judicial or an administrative proceeding that the application of the guidelines would result in an inappropriate or unjust order in that particular case. Findings that rebut the guidelines must state the amount of support that would have been required under the guidelines and include a justification of why the order varies from the guidelines. The issue of when deviation from guidelines is appropriate poses a challenge for states. Too many bases for deviation undermine the effectiveness of standard calculations, yet some flexibility is necessary to ensure that orders are realistic and can be paid in certain cases. While the standard guideline calculation addresses the basic needs of a child, deviation criteria tailor the order to meet the needs of a specific child or children. Federal regulations, in addition, require any deviation criteria established by a state to take into account the best interest of the child. Some states, such as Delaware, provide little guidance to the decision maker by way of deviation criteria. Others, such as Florida, provide detailed and specific criteria on what may constitute the basis for deviation. Those states that list deviation factors often list extraordinary medical expenses, as discussed herein, as well as factors such as educational expenses, the effect of a federal tax dependency exemption, or the presence of other dependents. Educational expenses. Deviation from guidelines for educational expenses are primarily attributed to costs such as private school tuition, programs for special needs, post-secondary or college expenses, or extracurricular programs and activities. In deciding whether to award educational expenses, the tribunal will usually consider the income of the parents and their decisions regarding educational issues when they were together. Factors can include the type of schooling the child was enrolled in prior to the separation or divorce, the special needs of the child for whom support is sought, whether the parents went to private school, whether the parents can afford private school costs, and whether it is necessary to maintain the child's current status and well-being. Some state guidelines have detailed criteria for deviating from the guideline amount for educational expenses. Tennessee, for example, lists tuition, room and board, lab fees, books, fees, and other reasonable and necessary expenses associated with special needs, education, or private elementary and/or secondary schooling that are appropriate to the parent's financial abilities and to the lifestyle of the child if the parents and child were living together, in the definition of extraordinary educational expenses, and allows the consideration of scholarships, grants, stipends, and other cost-reducing programs received by or on behalf of the child. Other states provide shorter lists of educational factors a tribunal can consider for a deviation. Indiana's guidelines define extraordinary education expenses as expenses for elementary, secondary, or post-secondary education and list criteria that could be relevant to justifying an award of child support for educational purposes. The commentary recommends the court consider whether the expense is the result of a personal preference of one parent or whether both parents concur, whether the parties would have incurred the expense while the family was intact, and whether education of the same or higher quality is available at less cost. The Indiana guidelines also contain a worksheet designed to apportion the cost of post-secondary education between the parents and suggests that the court may want to consider the value of tax subsidies that may be available in the apportionment. States often require an authorizing statute, prior case law, or an agreement of the parties for a tribunal to require payment of support after emancipation when the child wishes to attend college. Tribunals also consider other factors in ordering payment for college expenses. For example, the Indiana Appellate Court held that the parent's relative ability to pay college expenses should be considered, and the Massachusetts Appellate Court held that college expenses must be reasonable based upon equitable factors. The Court of Appeals in Arkansas allowed a deviation so that funds could be accumulated for future use by the child in attending college. Although some courts had held that ordering payment of college expenses violates equal protection, these cases have been overruled on appeal. Other courts have rejected constitutional challenges. Multiple family issues. Many guidelines in use today are based on the premise that both parents should share in the expenses of the family proportionate to their incomes, and that the child should continue to receive the same amount of support as the child would have received had the parents remained together. This premise, however, is difficult to apply in situations where the parents have never lived together. In addition, families are becoming increasingly complicated as more parents have children with more than one partner. Based on responses to a nationally representative survey administered by the U.S. Census Bureau, approximately 1 in 10 of all adults aged 15 or older have had children with more than one partner. There are many kinds of multiple families. In addition to families where the father has had children with multiple women, there are also families where the mother has had children with multiple men, or where both parents have had children with multiple partners. States therefore increasingly recognize the need to address multiple family issues within their guidelines. States address the multiple family situation in different ways. Questions policymakers must answer include whether the child support obligation to the first family should be reduced when one of the parents has a second family, whether prior-born children receive preference, and whether all children should be treated equally. Factors to consider are whether there is a court-ordered child support order in place for the additional child, whether the additional child is a biological child of the parent, whether the additional child resides with a parent, whether the parent has actually been paying support for the additional child, and whether the additional child was born prior to or subsequent to the child who is the subject of the proceeding. Income deductions and deviations. Many states recognize other dependents within the calculation of a parent's income, allowing a deduction from a parent's gross income for a support obligation the parent has for another child if the obligation is based on an order or a written agreement. In some cases, the deduction is only allowed if there is proof of actual payment of support for the other child. One criticism of the deduction approach is that it favors prior support orders, not necessarily first-born children. Therefore, if a later-born child gets to the courthouse before a prior child, the deduction approach results in less income available to support the prior-born child. Other states permit a tribunal to consider support actually paid for children with or without a support order, either as grounds for a deviation from the guideline amount or as a deduction from income. In California, for example, in the absence of a court order, any child or spousal support that is actually being paid is deducted from the gross income of the parent making the payment, as long as this amount is not more than the amount established by the guidelines. Arizona takes a similar approach. Imputed obligations. Some states address multiple family obligations by imputing a dummy support obligation for children who live in the parent's home and for whom the parent has a legal obligation to support, but who are not the subject of a child support order. This approach assumes that the parent is using part of his or her income to support the other child or children who live in the parent's household. Most states that use this approach calculate this imputed order using the guideline formula, although states sometimes use multipliers or require the use of the income of the child's other parent as part of the calculation. In Texas, the support obligation of a non-custodial parent who has a legal obligation for children in more than one household, including those who may be living with him or her, can be determined by the court in one of two ways. The first way involves several steps. Calculate the amount of support that would be ordered if all of the children lived in the same household. Calculate a credit by dividing that amount by the total number of children to obtain a per-child amount. Multiply the per-child amount by the number of children who are not involved in the order in question. Deduct the resulting credit amount from the net resources of the non-custodial parent, and apply the percentage guidelines to the net resource amount to obtain the child support amount for the children in the case in question. The second way to obtain a child support order in this circumstance is to apply the multiple family adjusted guidelines percentages to the non-custodial parent's net resources. Birth order issues. States also treat the issue of birth order of children differently. Some states have attempted to treat children from different relationships as equally as possible with guideline language, allowing tribunals to deviate from the presumptive guideline order, taking into account the total financial circumstances of all households. The New Jersey guidelines approach this issue with an other dependent deduction. This deduction is part of an adjustment mechanism to apportion a parent's income to all legal dependents, including those born before or after the children for whom support is being determined, and includes 3 separate support obligation calculations. Wisconsin guidelines contain an adjustment mechanism for use only when a prior obligation exists to the one in question. The statute specifically says that this adjustment cannot be used as the basis for modification of an existing order based on a subsequently incurred support obligation. In contrast, South Dakota allows a court to deviate from the presumptive guidelines amount based on the obligation of either parent to provide for subsequent natural children, adopted children, or stepchildren. Child support attorneys must understand the policy underlying their state or tribal support guidelines and present the relevant facts to the tribunal. Often the support amount in a case involving multiple children in different households will come down to a case-by-case determination. Child support attorneys can also assist policymakers in understanding the complexity of families in the child support caseload. Issues that guidelines reviewers need to address include not only policy decisions regarding the impact of birth order on support, but also the potential inequities that may result when parents have multiple children with multiple partners and/or one or more of the parents shares a household with a new partner who may be contributing to the family's finances, and the payment and receipt of child support across these households is uneven. Federal tax dependency exemption. Another consideration in the determination of child support is the federal tax dependency exemption. Typically, the custodial parent is entitled to take the federal tax dependency exemption. The parent can claim the exemption if he or she provides more than half of the support for the child, and the child resides with the parent in excess of 1/2 of the year. Federal law permits the non-custodial parent to claim the exemption when the custodial parent releases the claim to the exemption or where there are multiple sources for the child's support, none of which amount to more than 1/2 of the support. Tribunals in most states have held that they can allocate the federal tax dependency exemption and order parents to execute the proper Internal Revenue Service documents to effectuate the tribunal's order. The tribunal must determine when it is appropriate to allocate the exemption to the non-custodial parent and whether doing so will produce a tax savings and benefit by considering the parent's gross income, tax filing status, and relevant tax rules. After the tribunal allocates the exemption to the non-custodial parent, the issue becomes whether the guideline support amount should be adjusted. The commentary to the North Carolina Child Support Guidelines addresses the exemption and the effect of an allocation. It specifically permits deviation to increase the support amount under the circumstances. Many states consider who takes the exemption as a factor in determining the appropriate amount of support. Some allow for deviation to increase the support amount and others do not. The Arkansas court held that allocation of the federal tax dependency exemption automatically entitles the custodial parent to an upward deviation. Tribunals holding that they lack authority to impose income tax liability have been either overruled or criticized. Idaho amended its guidelines to specifically address the exemption, stating that the parent without the exemption is entitled to a pro rata share of the benefit in relation to the parent's share of the guideline's income. Other deviation factors. In addition to the deviation factors listed above, most states have a criterion called any other factor the court deems relevant to the best interests of the child or any other adjustment that is needed to achieve an equitable result. Parties have asked tribunals to consider many situations for possible deviation based on such a catch-all criterion. Tribunals have refused to allow deviations for the establishment of a bank account to cover expenses of the children, discretionary travel expenses that were not related to court-ordered parenting time, or a disabled child's receipt of Social Security. Appellate courts have also overturned deviations when court orders did not contain any reason or basis for the deviation. Tribunals have granted deviations in many other situations. They have allowed deviations when there were expenses for extraordinary medical care, when the non-custodial parent's income was difficult to predict, and when parties received adoption subsidies for their adopted children. Some tribunals have also allowed deviation from the guideline amount based on an agreement between the parties, especially where the non-custodial parent agrees to pay expenses outside of the guideline, such as college tuition or mortgage payments. When considering whether to recommend a deviation to the tribunal, a child support attorney should consider the statutory grounds for deviation, case law, fairness and equity of the situation, and the best interests of the child. Constitutionality of guidelines. Shortly after enactment of the federal statute that states develop presumptive support guidelines, there were challenges to the constitutionality of the federal mandate. All such challenges failed. Guidelines have also withstood constitutional challenges to the state's methods of enactment. Courts have held that the legislation of these guidelines no more unconstitutionally usurps the authority of the courts than does the legislation of mandatory sentencing guidelines. Non-custodial parents have raised other constitutional challenges to guidelines, particularly along equal protection lines. For example, in a case involving remarriage and a second family, the court did not allow a downward deviation in the guidelines because the non-custodial parent had 3 other children, holding that the difference in classification between children living with the non-custodial parent and those not living with the non-custodial parent was rational and did not violate equal protection. An Alaska court also rejected the argument that the Alaska percentage of income guideline violated equal protection by considering only the non-custodial parent's income. Retroactive application of guidelines. Courts have held that child support guidelines are not applicable to the de novo appellate review of child support orders entered before the guidelines' effective date. If new guidelines were applicable, most of the cases pending on appeal would have to be remanded for redetermination and consideration of evidence relevant to criteria used in applying the guidelines. Retroactive support. Historically, states often sought retroactive support back to the birth of the child. Many states currently have specific guidance in their guidelines regarding the possible retroactivity of support orders. Most states use the filing date rather than the service date as the appropriate measure of the beginning of the obligation. Courts have refused to impose a duty on a parent who has been barred from a relationship with a child during the period for which support is sought. Courts have, however, imposed obligations on parents during periods when they eluded service and location in an effort to avoid the obligation to support their children. Application of retroactivity poses particular problems for cases involving low-income parents, where retroactively compounding the monthly support amount can result in a large debt the parent can never repay. These factors are weighed carefully by courts in deciding whether to impose retroactive support obligations. Temporary support pendent light. Often a proceeding for child support is delayed to complete discovery, or because a party, attorney, or the tribunal is unavailable at the time scheduled for hearing. Because the need for support is so essential, many states allow the issuance of a temporary order for support pendent light pending the action. Typically, this amount is set based on income information that is available. For instance, usually the child support attorney will have access to wage statements. Temporary support orders rarely remain in effect beyond 1 year, and some states limit the time even further. Although temporary support allows money to reach children in a timely manner pending issuance of a final order, child support attorneys should argue against repeated use of temporary orders. Such orders encourage delay in finalizing and resolving the family situation, which can have negative consequences for the children and the parents. Duration of support obligation. All states have statutes establishing the duration of a support obligation. This duration is implicit in all support orders. The duration in state statutes ranges from age 18 to age 21. The most common duration of support is 18, unless the child is in high school. Then the duration is graduation from high school or age 19, whichever comes first. Many states have statutes or case law that impose a support obligation past the age of majority for children who are mentally or physically disabled. Some states will impose the support duty only if the disability arose during the child's minority. Some states also provide for support beyond the age of majority if the child is attending post-secondary schooling. In intergovernmental cases, UIFSA contains choice of law rules regarding the duration of a support obligation. Section 604 provides that the law of the registered under UIFSA. UIFSA also addresses duration of support when a party registers an order for modification in another state. Section 611 prohibits a state tribunal from modifying any aspect of a child support order that may not be modified under the law of the issuing state, including the duration of support. According to the official comment to Section 611, the original time frame for support is not modifiable unless the law of the issuing state provides for its modification. Therefore, in most cases, the registering tribunal may modify the support amount but not the duration of support. In the rare event the case has multiple support orders, it is the duration of the order initially determined to be controlling that governs duration. Most states that do not require support beyond the statutory age of majority will enforce an agreement between the parents that obligates one or both parents to provide such support. For example, although the duration of the support obligation in Mississippi is age 21, The court has upheld agreements to continue support beyond emancipation and given credit for payments made. Whether the Child Support Agency and Roman 4D attorneys provide assistance in enforcing an obligation beyond the statutory duration of support will depend on agency policy. In some states, the agreement to pay post-majority support is not subject to modification, nor is it a basis for deviation from guidelines. In other states, post-majority support is modifiable, even if the order is the result of an agreement between the parties. New Jersey leaves the decision to continue support beyond the age of majority to the discretion of the tribunal, who reviews the need and capacity of the child for education, including higher education. Case law has considered factors such as the definition of educational expenses, amount of support sought and reasonableness of the expenses, ability of the obligated parent to pay, financial situation of the custodial parent, and the parent's education and expectations for the child based on their social and economic backgrounds when determining whether to award post-majority educational support. Despite a statutory age of majority, most states recognize that a child can become emancipated earlier through marriage, military service, or employment, resulting in the child becoming self-supporting. Medical support. Federal law now requires that all child support orders shall include a provision for medical support for the child to be provided by either or both parents. Medical support includes provisions to cover health insurance costs, as well as cash payments for unreimbursed medical expenses. Child support guidelines must address how the parents will provide for the children's health care needs through public or private health care coverage and/or through cash medical support. Earlier sections of this chapter discussed how child support guidelines incorporate these requirements. This section focuses primarily on the requirement to provide health care coverage and the National Medical Support Notice in MSN. Tribal child support orders are not required to include provisions for medical support, although no regulations prevent tribes from issuing such orders. If a tribe does issue an order for medical support, it is entitled to full faith and credit. Federal mandates. The first connection between medical support and child support came as an attempt to recoup the costs of Medicaid provided to public assistance families under Title Roman 19 of the Social Security Act. 2 years after creation of the Roman 4D Child Support Program, the Medicare-Medicaid Anti-Fraud and Abuse Amendments of 1977 established a medical support enforcement program that allowed states to require that Medicaid applicants assign their rights to medical support. Further, in an effort to cover children by private insurance, instead of public programs, when available, it permitted child support and Medicaid agencies to enter into cooperative agreements to pursue medical child support assigned to the state. Also, state child support agencies were required to notify Medicaid agencies when private family health coverage was either obtained or discontinued for a Medicaid-eligible person. Child Support Enforcement Amendments of 1984. In 1984, the Child Support Enforcement Amendments added the requirement that child support agencies secure medical support information and obtain and enforce medical support in the form of health care coverage from the non-custodial parent when such coverage is available at a reasonable cost. Implementing regulations defined reasonable cost as the cost of insurance available through one's employment. Although the medical support requirements of the Child Support Enforcement Amendments of 1984 were helpful, obstacles to enforcement of medical child support still remained. For example, medical insurance policies contain provisions that limited the ability of a parent to add a child living outside the parent's household and not claimed as a tax dependent. Some plans disallowed children born to single parents or living outside a limited service area. Many times the parent would fail to enroll the child, sometimes because insurance premiums were too high. To hold the parent in contempt might cause the loss of a job that was the very source of support. Whether health care orders were enforceable under group health plans covered by the Employee Retirement Income Security Act of 1974 ERISA was unclear. Employee Retirement Income Security Act of 1974. In 1974, Congress enacted ERISA to help protect employer-provided pension and health benefits and to encourage employers to establish such plans. ERISA regulates most privately sponsored pension plans and health benefit plans. The law is important for child support purposes because it preempts state laws and regulations governing health insurance and employee benefit plans, including employer self-funded health insurance plans. ERISA also imposes requirements regarding information that must be provided to plan participants and beneficiaries, internal procedures for determining benefit claims, and standards of conduct of those responsible for plan management. ERISA originally made no mention of child support or medical support orders, and the original language limited a plan participant's ability to assign benefits. This appeared to prevent companies under ERISA from accepting an income withholding order sending retirement benefits to anyone other than the plan participant. The Retirement Equity Act of 1984 created the Qualified Domestic Relations Order QDRO to correct this problem as it pertained to child support. This change did not, however, allow employers to deal with medical support. The Omnibus Budget Reconciliation Act of 1993. The Omnibus Budget Reconciliation Act of 1993 (OBRA) 93 prohibited discriminatory health care coverage practices, allowed employers to deduct the cost of health insurance premiums from an employee's income, and created Qualified Medical Child Support Orders (QMCSOS) to obtain coverage from group plans subject to ERISA. Additionally, OBRA 93 included provisions that became Medicaid state plan requirements. Personal Responsibility and Work Opportunity Reconciliation Act. In 1996, the Personal Responsibility and Work Opportunity Reconciliation Act (PRWORA) required states, as a condition of receiving federal funds, to enact a provision for health care coverage in all orders established or enforced by the Child Support Agency. Before PRWORA, the requirement to seek health insurance coverage had been mandatory for public assistance cases, while non-public assistance Roman 4D applicants could opt not to have medical support established and enforced. Child Support Performance and Incentive Act of 1998. In 1998, Congress passed the Child Support Performance and Incentive Act of 1998 (CSPIA), which contained provisions to eliminate further barriers to establishing and enforcing medical support coverage. These included a medical support working group whose purpose was to identify the impediments to the effective enforcement of medical support, a National Medical Support Notice (NMSN), and a requirement for child support agencies to enforce health care coverage by using the NMSN. Federal regulations implement the provisions of CSPIA. A parallel regulation developed by the Department of Labor adopts the use of the NMSN under ERISA. The Medical Support Working Group completed its report in June 2000. The report contained 76 recommendations for expanding health care coverage for children in the child support system. Federal regulations in 2008 implemented many of those recommendations. Federal regulations implemented the NMSN, as required by CSPIA, in December 2000. The form has been amended and revised several times. Its purpose is to implement medical support orders by officially transmitting the health care coverage provisions for the children in child support orders from the Child Support Agency to the employer of the person ordered to provide the coverage. There are two parts to an NMSN. One part requires the employer to transfer the NMSN to the appropriate group health plan within 20 days of the date of the NMSN, and the other part requires the employer to withhold any amount of employee contributions required to obtain the insurance and send the amount withheld directly to the insurance provider. The NMSN complies with ERISA's informational requirements and restrictions and with Title Roman 4D requirements. In addition, the NMSN can constitute a Qualified Medical Child Support Order (QMCSO) for orders under ERISA, as discussed above. To be considered a QMCSO, the NMSN must contain the following information: the name of the issuing agency, the name and address of the employee participant, the name and address of the alternative recipient or a substituted official if necessary, and identification of an underlying order. Patient Protection and Affordable Care Act. The most recent federal legislation pertaining to medical support and health care in the United States is the Patient Protection and Affordable Care Act (AK). This law makes many changes to health care coverage that impact the child support program. These changes include a requirement that all applicable individuals ensure that they and any of their dependents under the Internal Revenue Code are covered under health care coverage defined by the ICAE as minimum essential coverage. This means that the custodial parent, the applicable individual who claims the federal tax dependency exemption, must provide health care coverage for the child, which may conflict with a support order or divorce decree for the parties. This conflict can be resolved through the use of an IRS form that allows the custodial parent to release his or her claim to the exemption and permits the non-custodial parent to claim the child. The release also requires the non-custodial parent to obtain health insurance coverage since the child is now a dependent of the non-custodial parent. As a result of the ICAE, child support agencies may receive referrals from Medicaid, which may or may not be appropriate child support referrals. This is because the ICAE requires the use of a single, streamlined application process for those applying for medical insurance through the healthcare marketplaces. Although some of those applications may involve custodial parents and child support-eligible children, many will not or will not contain enough information to identify a non-custodial parent. Nevertheless, these applications may be referred to child support agencies. OX has taken several steps to clarify the effect of the ICAE on child support enforcement. In the case of Medicaid referrals, this guidance encourages child support and Medicaid agencies to work together to identify referrals that are not related to the child support program or to prevent those referrals from being made at all. States may also want to consider revising medical support policies to enhance collaboration with the Medicaid agency and cross-train workers. OX has clarified that federal financial participation funds are available for activities that provide outreach and information to CHIP and Medicaid to assist with enrolling children. OX has taken additional action to facilitate changes resulting from the ICAE. These include issuing grants that allowed child support and Medicaid agencies to work together to identify issues resulting from differences between the ICAE and then existing medical support policy, issuing policy guidance, clarifying that child support agencies may order either public or private insurance coverage, and clarifying allowable activities for FFP. OX has also developed a series of fact sheets designed to provide the child support community with information and resources about the ICAE. Because of the impact of the ICAE on the child support program, child support attorneys should pay particular attention to evolving case law on the ICAE, as well as guidance from OX on this subject. OX has also directed states to review their laws, rules, and policies to ensure compliance with the requirements of the Medical Support Final Rule and the flexibility, efficiency, and modernization in Child Support Enforcement Program's Final Rule. Child support attorneys can play a critical role in that review. Conclusion: establishment of child support and medical support orders is a crucial first step to ensuring that children get the support they need. Child support attorneys play a critical role in providing information to tribunals so they can appropriately apply the support guidelines and enter realistic orders based on the parties' ability to provide financial and medical support. Attorneys also often play a role in the quadrennial review of guidelines, serving on guidelines commissions or providing testimony regarding application of guidelines. Issues that are increasingly the focus of guideline reviews are the treatment of low-income parents, imputation of income, multiple family issues, shared parenting time arrangements, and medical support.